of India has recently simplified the procedure for passive euthanasia in the country by simplifying the existing guidelines for living wills as laid down in the 2018 landmark judgment titled Common Cause versus Union of India, which had recognized the right to die as a facet of the right to live with dignity under Article 21 of the Constitution and had accordingly upheld the legal validity of passive euthanasia. On January 24th, a bench comprising Justices K.M. Joseph, Ajay Rastogi, Anuradha Bose, Rishikesh Roy and C.T. Ravikumar agreed to make the process less cumbersome by modifying the existing guidelines. This particular order was uploaded recently. But before we discuss what the Supreme Court's latest ruling is all about and the legal issues involved, let us exactly find out what a living will is and what is passive euthanasia. As many of you must already be aware, euthanasia refers to the practice of a person deliberately ending his or her life due to an incurable medical condition. Euthanasia, which can be administered only by a medical practitioner, can either be active or passive in nature. Active euthanasia involves an active intervention to end a person's life with external substances such as the administering of a legal injection, whereas passive euthanasia refers to withdrawing life support or medical treatment that is essential to keep a terminally ill patient alive. Now, a living will or an advance directive is a document that a person can execute well in advance, explaining his or her wish about withholding medical treatment in case of a terminal illness with no possibility of cure. So what exactly did the Supreme Court rule back in 2018? Aruna Schonberg, a former nurse at King Edward's Hospital in Bombay, was sexually assaulted at the age of 25. She died of natural causes in 2015. Although her 2011 petition to stop administering life-supporting drugs to her was dismissed, it helped the Supreme Court arrive at its 2018 landmark verdict. The Supreme Court, in its landmark verdict in the case titled Common Cause versus Union of India, allowed passive euthanasia while recognizing the legal validity of living wills of terminally ill patients who could go into a permanent vegetative state. The Supreme Court, in its 2018 judgment, recognized that unlike other countries, there was no legal framework in our country with regards to advanced medical directives and accordingly issued a host of guidelines relating to the competence of an individual to execute an advance directive and the procedure that is to be followed in such cases. A 5-judge constitution bench headed by the then Chief Justice of India, Deepak Mishra, said that the guidelines would be in force until the Parliament passes a comprehensive legislation on this. Since no legislation in this regard has been passed yet, the 2018 judgment is the last conclusive and authoritative set of directions on euthanasia. However, these particular guidelines of 2018 are cumbersome and they lay down a complicated procedure, thus making it difficult for patients to execute a living will. So what changes have exactly been brought about by the guidelines issued by the Supreme Court in its latest ruling? A petition was filed before the Supreme Court by a non-profit association called the Indian Council for Critical Care Medicine, which argued that the 2018 guidelines on living will had become virtually unenforceable owing to the complexity of the procedure prescribed. Previously, under the 2018 guidelines, living wills or advance directives needed to be executed not only in the presence of 2 attesting witnesses, preferably independent witnesses, but also countersigned by judicial first-class magistrate. However, now it is sufficient if the living will is attested by a notary or a gazetted officer. There is no requirement for it to be countersigned by a judicial magistrate. Previously, the judicial magistrate was required to inform the family members, that is the immediate family members of the patient, as well as the family physician if any. However, now the patient has to just hand over a copy of the living will to the designated decision makers and the family physician, if any. As per the procedure laid down in the 2018 judgment, the treating physician was required to constitute a medical board comprising 3 expert medical practitioners from various fields of medicine with at least 20 years of experience who would decide whether to carry out this particular living will or not. If the medical board granted permission, then the will had to be forwarded to the district collector for his approval. The collector was then required to form another medical board of 3 expert doctors, including the chief district medical officer. Only if the second board agreed with the hospital board's findings would the decision then be forwarded to the judicial first-class magistrate, who would then visit the patient and examine whether to accord the approval. However, now, under the new guidelines, instead of the hospital and the collector forming 2 medical boards, both boards will now be formed by the concerned hospital. The requirement of 20 years of experience for the doctors has been relaxed to 5 years. The requirement for the magistrate's approval has also been replaced by an intimation to the magistrate. The medical board must communicate its decision within 48 hours, whereas under the earlier guidelines, no such specified time limit was mentioned. If permission to withdraw treatment being administered to the patient is denied by the secondary medical board, it is now open to the nominees of the patient or the treating physician or the hospital staff to file a writ petition before the concerned High Court. Thank you. Let us know what you think of the Supreme Court's latest ruling on this subject in the comments below. We would love to hear your feedback. I'm Aratra Gabhomik for LiveLaw. Keep watching LiveLaw for more such updates.